may call it a compromise. I think it could also be illustrated by the phrase you mentioned to me earlier, namely that the court is barking, but it never bites. I think the previous commentator put it quite correctly when he said that clearly the court thinks that the ECB is acting unlawfully. It said so in 2017 in its first decision in this matter, when it also decided to refer the case to the European Court of Justice. In 2017, the court was quite clear that the ECB was engaging in monetary state financing, which is prohibited by the treaty, and that it was also engaged in policy making on a large scale, something that the treaty reserves for member states. Now, it's essentially reiterating these points. The court reasons very well, but it lacks the courage to act on its own reasoning.
Gunnar, can I ask you, obviously this is not a ruling on the pandemic emergency programme. Are you interested in pursuing this issue with regard to that specific programme?
Well, I should just make one correction. I think the lady who asked me the first question said I was one of the plaintiffs in the case. This is not correct. I was involved as a lawyer initially until about 2017, not since I've taken up a political appointment. Now, to your second question, it's quite clear that the new pandemic emergency program marks yet another stage in the development of what is essentially a central bank bankrolled European economy. In particular, insofar as bonds are no longer bought according to the capital key, there's a clear concentration on Italian and Southern European bonds. So we have to review the situation. It's a tall order insofar as the court is always reluctant to do anything. And I think that's what we've seen today. It doesn't like what it's seeing, but it isn't prepared to challenge the European Court of Justice or the government.